Right, sir. So good evening, everybody. Am I audible to all of you? I welcome you all today to the CoE-IP and MSH webinar series, session 2. This webinar series is being hosted in conjunction with KNS Partners. KNS Partners is an acclaimed intellectual property rights boutique law firm of the country. To introduce ourselves again, CoE-IP, or Center for Excellence in IP, has been established at MeitY to offer a gamut of intellectual property rights services to academic institutions, scientific societies, and the like, and has played a crucial role in streamlining and transforming the IP landscape. MeitY Startup Hub, or MSH, has been established under the aegis of Software Technology Parks of India, or STPI, which is an independent and autonomous society under MeitY. It has been established with a vision to streamline, boost, and strengthen the technology startup ecosystem of the country. Our topic for today is patent strategy for tech startups. It is my privilege to introduce you to all our speaker for the day, Mr. Naveen Surya, partner, KNS Partners. Mr. Surya has been handling patent prosecution and filing in the areas of semiconductors, electronics and communications, digital systems, and the like for many years, and has also handled opinions on patentability and freedom to operate. Sir appears before the Indian Patent Office and the Intellectual Property Appellate Board in connection with patent prosecution very regularly. Over to you, sir.
Yeah, thanks a lot, so, and also thanks for the wonderful session put together for us here. Thanks a lot for also sharing this nice topics which we'll be dealing with along with collaboration with IT. So I believe that this presentation will help all the participants in terms of getting those information what they are expecting. And here I like to say that I would like to keep the presentation very brief. I would not spend much time on the presentation, maybe max 20 minutes. And I'd be happy to take up more questionnaires and listen to audience here and try to understand what they want and give information which is more relevant for them vis-a-vis the topics what's been here today to discuss. Go about, I think the topics for us is these five: necessity of patents, timelines, patentability search, freedom to operate, and understanding financial ramification. So I'll briefly talk about that and try to cover a few things, which later on I think we can take up more questionnaires on these topics to help us. Just give me a second. Yeah. Am I audible now? Is it clear?
Yes, that's better. I request you to be a little louder though.
Okay. Yeah. And go about. So what is the necessity of patents basically on the startup segment? Why they have to look into? So one is that to protect your market share. So here, if you see the market share, I think a figure indicates that a box here indicates a particular area of technology the startup is working into or would like to indulge and try to make some difference. And here you have the competition. Now the land mines here, it shows the mines here. So it's a land mines. We call patents are something which is equivalent to filing land mines. So we are talking about filing different patent application, and it's been visually indicated or to say so as landmines. Now, if a particular person or a startup who's entering into a particular area or a technology files a good number of patent applications which should appear as a landmines in that area because they are pioneer in that. Now, any competition when they want to come into or enter into that specific area of technology and they would like to work into because they see market there, they see some potential there, and they would like to enter, First, they like to see here is this particular landmines. And what they don't want to do is to step onto any of this landmine. We all know what happens if someone steps onto landmine. At least in this particular context, it would actually incur a lot of losses to the competitors if they step onto landmines. So they need to be very careful that they don't, when they are entering into this area, they don't step into any of these particular landmines. So it becomes really difficult for them to carve out a niche area where such landmines is not there. Now, when competition is coming into picture, and if they see that there is not much of white space appearing for them, so that they can play around, so the competition would actually think twice whether I need to enter into this area of technology or not. Now, what startups or the people who enter into this particular technology can do is they try to fill up. They can strategize their particular business so that they can fill landmines in all these white spaces or the area which they intend to cover or protect or to create economy from that particular areas. So what patent would do is that one is that it would create some amount of deterrent for competition to come into, protect your market share, and also plan your business strategy accordingly so that you can expand your business in that area of technology. Next is that it's going to attract a lot of investors. I mean, investors would like to see what is the market area you have captured, which eventually would you like to enter into. It's just not that what is the market area you have as of now. It is also that how much market area you are able to protect for yourself for your future. I mean, investor, when they try to invest, they see a lot of factors. I mean, as startups, you all know that in terms of team, what is the product, and all those things. And they also know that when they invest now, the returns is not immediate. They know that it's going to take some time for them to take that investment out. Now, during that particular timelines, they would also like to see how well your area of business is protected, so that the market what you're seeing today, will the same market exist for you in future or not. I mean, market will be there, but whether that market is there for you to take up or not is something crucial. Because we all know that when someone also started the business, no one would like to start a business just like that. I mean, they would have some futuristic look. They would have done some market analysis. They would have done some survey. They would have got inside information in terms of what is the business available for them in coming years, and accordingly enter into that particular market. Now, if everybody who's doing that analysis get to know that whatever area you are into is what others also will get into tomorrow, then what is the niche edge you have vis-a-vis others? Where is the edge you have, or an upper, or to say an upper hand vis-a-vis others? So that's where investor also would like to see how much you have blocked that particular area, so that you can venture into it, if not today, tomorrow, as the business expands. Now, it will also give you a lot of sustainability and growth for business. Now, you know that, look, no startup will enter into millions of dollars in their pocket and as soon as they enter into the
Some
market, they
problem with
have
audio, sir.
just a second, sir. I think I had some problem with internet issue. Just a second. Is it fine now?
Yes.
Is it okay, sir? Yeah, sorry, there was some disruption on internet from my end. Okay. Now, what I mean, as what I was saying is that not all startup would enter by saying, okay, I have 50% market captured. I think Everybody start with the notion that let me start small, let me start with a single client, again increase it, again small, step by step you try to increase your market share, and eventually you try to grow. Now, this particular thing takes a lot of time. It's not that it's going to happen overnight. Now, for that particular thing to happen over the time, you should also have that sustainability within your business that, okay, tomorrow, if I had to go in this particular order, I'm sure that in next 1 or 2 years, the amount of market I would have captured is X. Now, for that, you should be assured to certain extent that yes, whatever product or whatever business proposition or methodology or the solution which I'm trying to sell to the market would sustain for next 2 to 3 years, so that I can expand my business in that direction. Now, for that, unless you don't have something concrete placed or there in the market to showcase that yes, this market is for you, you can't say that okay, tomorrow you get up without that assurance. You could see there are another 2 to 3 startups giving the same solution, and their client is same as your client. Your target client is also their client. Now, you're not very sure or assured that in next 2 years time who is going to make the cut. So a patent should actually help you to block that areas for you, so that you have that peace of mind, and you can also see the progress for your business and acquire those particular clientele which you had initially thought of when you actually started the business in coming time. I mean, all big clients don't end up with the startup on day one or the first month. I mean, eventually you need to put in a lot of efforts, and only then you're going to get them. So this could be one of the way where you have some peace of mind that okay, if tomorrow someone wants to enter into this particular market, they should be well aware that there are some patent minds which I've kept in to ensure that
Some problem with audio, sir, Naveen ji? Not able to hear you, sir.
give me a second, sir. Let me check my internet. Okay, is it fine now, sir?
Yes.
Sorry, I have some internet issues at my end. Apologies for that. Okay. A lot of startups do ask this question in terms of what is the right time for us to file a patent application, because that is not something on the priority list, because they have to deal with so many n number of things with them in terms of building the team, market, administrative issues, and R&D, coming out with new products, trying to keep the existing clientele happy, troubleshooting things. They have so many things going on in their mind and on priority. Usually they'll be working in the quadrant where most important and most urgent things. They always be working in most important, most urgent things. So that way, patent may not come in their mind as a priority. But what I would suggest is here is that as the statement goes, please try to file a patent application as soon as possible. The reason being is that, look, it's not only you who is working in that particular area. We should also keep in mind that there are other people who are also playing in the same area. Also, you should keep in mind there are certain big players who, if they see certain market here, for them to expand into the market may not be big that difficult because they are well established. Only thing is that they need to put in little more investment and get people into on board and try to give objectives which is same as yours to them, so that they can venture into that market. So as startups, the major problem, what is that though you see a big market there, the others are also looking into that particular market. So timings becomes very crucial here. If you have an idea And if you believe that's an idea which is going to keep your business running, and that's the direction you are going into, please file a patent application as soon as possible for it. I mean, uh, there are ways to do it. I mean, people say that, okay, patent filing is a difficult thing. It takes a lot of time for you to get a patent. Also, going through and filing a patent application would actually means a pain point. It takes a lot of time. My suggestion would be at least think of filing a provisional application. There is an option called provisional application. It will not cost you much. It will not take a lot of your time, and it can be filed very quickly. The other advantage you get is that you file a provisional application now and you forget it. You can actually think of filing a complete application after, another 12 months time. So since, as I told you, like a lot of startups will be focusing on or working on the matters which are more important and more urgent than patent filing. By filing a provisional application, you can actually delay things a bit and try to complete it in next 2 to 3 months or next 6 months time, where you pin and say, okay, in 6 months time, I'm going to work on this and try to complete it. Also, not every idea which comes to your mind is going to be a blockbuster. You're not very sure at that point of time. When you're trying to find a solution for a client, you come up with something new idea, but you're not very sure that if this particular uh, uh, idea is going to be a blockbuster. Maybe that particular solution gave some relief to the client then, but maybe in 6 months time the line you have found a better solution than that. So even in this situation, provisional applications will help. That let us say that you are able to resolve certain problems for your client and you came up with something new. You filed a provisional application for that, and tomorrow in another 3 months time you came up with a different solution which is much better. File a provisional for that. In another 8 months time, the solution what you're trying to propose is way different from one and two, and you know that this is the solution which is far better, and tomorrow to sustain your business, this is the solution you're going to use. At that point of time, the provisions what you filed, you don't have to actually take it forward. You can only take forward the third idea as a patent application. So what happens is that the one and two is not disclosed in the market because it's a provisional application. Nobody knows that you filed such a patent application, and it remains as a trade secret. And so you're not even taking forward because by that time you have the clarity telling Baba, I don't want to work on that. So what happens is that gives some sense of relief that your idea is there, because you filed a provisional application, you get an application number and a date. It is blocked somewhere, but it gives me more time, around 12 months time, that to decide on whether I should take that idea forward or not. At least the example what I gave in 1, 2, and 3, I think the last idea was the best idea to take it forward. Maybe who knows, the first idea itself was the best idea. 2 and 3 solution what you proposed did not work well. So at the end of 1 year, you can actually take that solution one forward by filing a complete application. So this could be one of the strategy you can think of as startups. And this is crucial for all the startups, that you protect your core idea. Some misconception is that people think that by filing one patent application, my core idea is protected. As you know, once you have a core idea, when you start working on it, when you start providing solution to the market and trying to resolve certain glitches what people had, you end up having a lot of smaller solution around your core ideas. So I think all the solutions put together along with your core idea becomes a strong patent protection, or you can call it as a core technology. Unless you don't have that smaller cluster around your core, believe me, it becomes easier for other people to work around it. Or maybe in 3 years down the line, someone would have come out with a better solution than your core idea, and we're giving that solution out. Now, unless you don't fill up these clusters around that core idea, your idea would not be a sellable proposition. Maybe down the line in 3 5 years time, 3 years 5 years time, your idea may not be a sellable proposition. There are a lot of players sitting in market selling better solutions. So always try to file clusters of patents around your core so that that is well protected. What you've seen, I mean, we have seen a lot of startups who are coming out with just one or two ideas, and we have seen that they're not doing much after that. They have not even put any efforts in terms of R&D to work on it, but they have found themselves in very difficult situation in 5 years time. So it's always good that put your R&D team and try to build around your core solution and try to make it more stronger as time goes by, so that this would fetch you fruit in coming years. I mean, one of the other most difficult situation for startups is the time and money. So what we say is that you have provisions to delay your expenses. So please utilize them. I mean, in terms of how the issues in terms of money and cost could be addressed, I think it will be coming on next slides. But at least in this slide, the information is that you can delay your expenses so that you can utilize that funds and the timings for something else. One of the ways you have is to file a PCT application. So the advantage you get by filing a PCT application is that you can sleep over it for 30 months time. You file one PCT application now, and in next 30 months, you don't have to worry about it. You have to open your eyes and look into that particular application only at the 30th month or last 6 months of the 30th month. What is that I have to do? So your idea is protected till then. You can think at that point of time whether I should take this idea into more than India. Should I take out this idea into US, Europe, and other developed countries, or should I focus only on, let us say, that into Japan, Korea, and other places? So this time is good enough for you that it will tell how in which direction your business is going, and whether that particular idea contributes anything to that particular business which is growing in certain areas. So keeping that in mind, you can actually think of filing application in those countries. Here, a PCT application is just one application, which will give you 30 months time, so that you can file the same idea in other countries. So just file one idea as a PCT application and just wait for 30 months, and then you can think over and see you can file it in other countries or not. The PCT application here covers about 150 countries. Almost all developed countries in major countries are covered here. For example, US, European countries, Japan, Korea, China, all major countries are covered, except few countries like Pakistan, Bangladesh, Bhutan, Sri Lanka. I mean, those are the countries which are not covered under PCT. So please use a PCT route, which would help you to delay your expenses and also give peace of mind for at least 30 months to see whether to file in other countries or not, and also to ascertain how business is shaping up during that time. The other advantage you get is that you also get a search report to PCT authorities, which will tell whether how good or bad your idea is to get a patent. So that way also you can decide whether to take your idea forward or not, or also says how good your idea is. Please use this option of India's search authority. It has a lot of advantage. One of the major advantage you get is cost benefit. So you end up saving a lot of cost with India's search authority. And second is that if you file India's search authority, it will help you to expedite your patent in India. You can actually get a patent granted in India in 6 to 9 months time if you are using India's search authority. And also facilities what people are not much aware of. Please use these facilities for you to get funds. A lot of initiative from state governments, including Karnataka, Andhra Pradesh, UP, Gujarat, Maharashtra, and there are a lot of other countries, even Goa too. If you just Google and say that what are the remuneration provided by these states for patent filing, you just Google it and you will get all the information you need. And please use those sources to fund your patent application. There are lots and lots of it. For example, they fund you for filing in India. Some of the states fund you to file PCT application. Some of the states file you to even file an application outside India, and the amount is also, I mean, it's substantial. Frankly speaking, at least I'm aware of the refund which is provided by Karnataka, at least remuneration. I think the amount is very, very attractive. As such, I don't think even a startup should even shy away in using these things. I think they should be more pro to it and utilize those funds. Also, I'm aware that all those funds which has been allocated in these particular states, at least few states, the entire fund just remains after 1 year, and people are not even claiming those funds. So I request startups to utilize that particular state-wise funds available for patent filing to get remuneration. Some states remunerate the entire amount. Some states pay up to 80% of it. Some pay 60% of it. Some say that okay, part of the funds will be refunded to you during filing stage. Part of it could be done at later stage. So please utilize not only state government, lot of initiative, including MeitY, TIFAC and all. They are providing funds and they're trying to support certain initiatives so that they encourage people to file patents. There are certain areas too. There are certain organizations, for example, MeitY, if I'm not wrong, they encourage patents related to electronics and information technology so that they can fund them. Similarly, there are organizations, if your invention is in the area of biotechnology, they will fund it. Similarly, there are organizations which will fund you if you have filed a patent application in the area of green technology. You have to just Google it and say that refund for my area of state wise or central government wise or area of technology. You will get all the information. Please try to utilize that. They would have some caps, but please try to use them. Okay. I'll take up the questionnaires at the end. You can put all those things in the chat box. Coming to patentability search, when is that you have to do? Before you start finding a solution. People think that I have to do a prior art search once I think of filing a patent. No. Please, when you have to give a solution to any of your problem, please do a prior art search, because the solution which will come out after 2 or 3 months of your own research, R&D, there could be lying there for you as a patent application. So please, or even non-patent application, please do a search on the web. What could be the solution for so and so problem? There could be a lot of solution lying there, which you can actually adopt. Frankly speaking, you can directly adopt the solution, because there may not be any patent application or IP blocking that idea in India where your market could be. Or for example, you're trying to provide a solution to Japanese client and you may know that there is solution existing in US, but that particular solution is not being protected in Japan. Please adopt it. Or the second advantage, what you get is that if you know that such and such solution exists, you can actually build beyond that. You can try to come out with a better solution than what is existing. So your R&D would actually start from that stage. You would already climbed a step up by finding that solution on the net, and you're trying to work beyond that. So a lot of time, efforts get saved if you're able to start finding solution even before thinking of patents. So please do that search. You will get a lot of patents, a lot of non-patent literature, which is talking about that solution, and you can always improvise or try to implement the same if it's not protected in that country. Second, before filing a patent, for sure, don't assume that since you are filing a patent and you have done R&D for last 6 months, don't assume that nobody is there. Please get a search done before filing. The advantage is that you don't have surprises later. Second, you save a lot of cost. Third, you can actually think of workaround solution before filing a patent itself if you know what and all patent exist, so that your patent can be much, much stronger. These are the various websites available where you can do your search for free. There are paid database also available. I think you have to pay a lot of money for it. So, but I think these free database are good enough for you to do a preliminary search in terms of patenting. Seek expert advice. One more important thing is that if your idea, you're doing a search, and if you believe there are solutions existing which is similar to your idea, please don't get disheartened and drop your idea. Always discuss your idea with experts in terms of, can I take a patent for it, or can I get a patent for it? Even there could be a minor change, different. uh, Please ask the idea, please take expert advice, because almost more than 95% of patents filed across the world are mere improvements. So that way, the difference what you have in your idea vis-a-vis what is existing, you may not see that as a big one, but an expert can help you to say whether your idea is still worth taking forward for a patent or not. I just have few ideas here to showcase how one can think of filing a patent. The simpler ideas could be patented. One thing here I'm showcasing is, as you know, we all have dashboards in car, and we also know that there is fuel which is usually at the rear end of the car. This guy just put a transmitter and a receiver system, one at the fuel gauge at the display, and one at the fuel tank. So remotely, this was transmitting how much fuel you had, and they were able to display that on this. The advantage, you were able to avoid wires here, and this got a patent, and that is not very 40, 50 years back. We were to get patent just 20 years back. So you may think that, okay, what is the big idea or big deal here? But believe me, you will be able to get that, because they were able to say a lot of rat rodent problems, which cuts off all the wires in between, and it's a big pain point, and total wiring is avoided. And also, wiring, doing wiring in an automobile is not an easy job, because they have a lot of constraints where they can take wires through to the dashboard. So all those advantages you get through wireless, and you're able to get a patent. Similarly, you may say that, okay, this is a small paper clip. Paper clip is known now. Why should I think of that? Now here you have a different paper clip, which is turned little differently. Again, this is the second paper clip. Again, it's doing the same job, but it looks a little different. Again, there's a third one. Again, it's a paper clip. It looks almost very similar. I would be a little surprised to say that all these three patent clip has its own advantages, and all these three paper clips are patented after this paperclip came up. So small changes also will help, and the advantage you get because of that also will help you to get patents. So please look through it, take expert advice whenever you see your idea very similar to an existing idea. Uh, Freedom to operate, it is your ability to exploit your development, a product, without being risk of being sued of infringement. For example, let people think that, look, I have filed a patent, now my product can enter into market, but that's not true. Though you may have a patent for your idea, but while entering into the market, there is a possibility someone may sue you for infringement. To explain this, I've taken this figure. Rectangular box, let's say that it's a product of yours. Let's say some air purifier or something like that. You have come up with the product, and for that you have filed one patent. Maybe the way the electronics works, or the way you're trying to purify something over there, you try to file a patent there. Now, if you see in the market, there are a lot of other patent X, Y, and Z, which are actually protecting different parts of your product. So you filed one patent for your product, it is just trying to cover one part of it. Maybe somewhere in the air purification state, the methodology here is what you're trying to protect. But the patent here is trying to protect the channels, the way the air passes, the power which is being efficient in that air purifier by way of controlling the amount of air getting purified. And there is another technology within the air purifier. So if your product is using any of these particular product along with your patent, if you want to launch it, you should be careful that these guys XYZ will come behind you and try to sue you for your product. So you should always get your freedom to operate done before you launch your product, so that to identify these players X, Y, and Z, so that after you launch your product, you don't want a legal suit and try stopping this product. So all your clients may not be very happy that after getting the product, they're not able to get services, or not able to produce more products from you. Always have a freedom to operate search there so that you don't fall into this trap. I'll take an example here. Let's say you have a product C. C, which is a blue circle, is your product. Let's say there is a technology A, which is available in public domain. And let's say there is a B, which is a patent been filed. Now the question is, can C be commercialized? Can I commercialize the patent C? You can leave your answers on the chat box. If I can commercialize C, knowing that there is one public domain disclosure and one patent here.
He's in 13. 14 rather. 14.
Yes. Many of them are saying yes. Good. So people are saying yes, you can commercialize your product, which is C. Now the next question is, can C be patented? Can I file a patent for this C, which I come out with? What is known from the public art is A. What is known from a different patent is B. Now what I come out with is C. Can I get a patent for it? No. Okay, there are a good number of no's here. Okay, great. Now let's see what is this. Now coming to the first part, that is, can C be commercialized? I'm talking about this point C. Can C be commercialized? C can be commercialized provided if C has taken license from B.
Correct.
If C has not discussed with B, and let's say C launched this product, and B finds that the product of C is having his own patentable idea, which is B, then B can actually stop this product being commercialized. So C need to seek B's opinion in terms of launching his product and take license if need be or buy that particular idea before he launches this product. So can C be commercialized? No, unless because there is a patent B which is residing and it will not belong to C. It is yes if C has rights of the patents of B, then is free to commercialize. A, which is in public domain, that will not disturb you at all. One need not worry about it. Now, can C be patented? Because a part of C, which is lying here, is already patented. Now, can I patent this C? Yes, you can patent this C, provided that it is giving certain advantage. Nobody knows about C. People knew only about B and A. Nobody knew about C. Yes, they can get a patent. As okay, B resides in C. Yes, even then he can get a patent, but he cannot commercialize because of this. So getting a patent is not a problem here because B is part of it, which is owned by someone else. But if you have to commercialize, it becomes a problem because you need to seek a license from B. Just a small example here. Understanding financial ramification, I think a major cost one can incur is during filing of a patent. There is a huge chunk. And during the examination, which may happen after 6 months, after 1 year, the examination may happen. So these are the two places where a startup has to incur major cost. Apart from that, you just have to have minor cost. This is during the prosecution, that is after you filed a patent application and before it got granted, there could be some minor cost involved in between and annuity payment. So once you get a patent granted, you should make sure that you pay annuity every year so that that patent is alive. It's just like paying taxes to your house or trying to pay monthly rental or something like that. You can take it that way. For your patent to be alive for next 20 years from the filing of patent, you have to pay annuity. So these are all minor costs. So I'm so sorry, I don't think I've completed in time, but I'll be happy to take any questions. My apologies for taking more time of yours.
Yes, Mr. Surya, thank you.
I think there are two questions.
Okay, I'm just reading the chat box. I'll just answer the questions which are already here. You may put in other questions as I'm answering the first one. So first one, what you see is that patent grant takes years. I have seen some cases to decade by the time technology is absolute. Yeah, you're right. I mean, that was the state long back. So from last 3 years, patent office have hired a good number of examiners, and we see that a good number of patents are getting filed. I mean, getting granted soon now. The average time now I'm seeing is 3 years. Any application filed in 2019, you're already having an examination report, and by end of the year, it gets granted. So right now, the backlogs has been reduced to 3 years. I mean, even in US and Europe, it also takes around 3 to 3.5 years for us to get a patent granted. Second, if you really want to get your patent granted much earlier, if you are a startup, use that provision. As a startup, you can actually get a patent granted in 8 to 10 months' time. On an average, 9 months, you get a patent granted. Second, if you don't belong to a startup category, please file a PCT application with India Search Authority so that you would actually qualify your Indian application to get expedited. And again, once it gets expedited, you'll have a patent granted in an average 9 months' time. So you can please utilize those options available. I'm moving to the next one. How can you file an IPR on basis of software code? I mean, codes as such are not patentable. So the idea is what is getting patented. The idea along with technology is what gets patented. So a lot of things nowadays are developed on softwares. Uh, and we all know that we have some issues with software. But vis-a-vis IPAB decisions and court decisions, high court decisions, now patent office is more inclined to grant applications which are built on software. So it is not that software in a whole is not patentable. If your software is able to resolve certain technical problem and give certain technical advantage, you can always think of filing patent for it. It is the software, the way it works, and not mere software codes or that program which gets patented. So please talk to experts over there so that to help you to get a patent. So please don't have in your mindset that if it is software, it's not patentable. Softwares are patentable in India, but you have to present it in certain way that it shows technical advancement and it has technical advantage to it. Next, any cost figures in filing to grant? Maybe you have to budget yourself around 2 lakhs from filing to grant, including official and attorney fees. If you are filing by yourself and you want to get a patent done, the government fee would be less than 20,000, around 20,000 rupees. You can get a patent granted. And as I told, the amount is two bigger chunks. The two bigger chunk is attorney fee usually. If you are filing on your own, around 20,000 is just you have to spend it during filing stage, and you may not have to file. I mean, you do not have any cost until it is granted if you are directly dealing with the patent office. If you're hiring an attorney, filing stage it could be a bigger chunk, let's say around 80,000. And again, a second chunk when you get an examination report, there could be around 80,000 rupees or 90,000 rupees. So roughly it is that. And it's not that expensive because you have experts who can draft and help you file application in much lesser cost. The cost can be even just 50,000 from filing to grant. It all depends on which expert you hire and accordingly take it forward. So the cost varies. patent is on design and process. Yes, you can get it. How startup can license their patents to third party? Yes, you can license it. I mean, you can take expert advice there. Please market yourself well so that people should know that your product is available in market for licensing. One way you can do is that while filing a PCT authority, you can declare there itself that this particular patent application is available for licensing. So after you file a PCT application and file that application world over, so everybody can see that that disclaimer that you are open for licensing it. And there are a lot of portals available where you can be part of them and say that this is my patent. I'm ready to actually license it. Please Google it. You'll find it. Uh, One of the things that I think even in Denmark Patent Office provides this option that you can actually put your patent over there and say, okay, this is available for a license.
Surya sir, I'll just interrupt.
Yeah.
There are a couple of questions from Mr. Anup Kumar Prasad.
Yes.
So we also request you to share your LinkedIn ID, which you could do so in the chat box. In addition to that, Mr. Prasad would like to also ask that should we go for Indian patent, Australian patent, etc. for healthcare devices?
Look, it depends on what is your market. I mean, wherever you see the big market you have, that's where you need to file a patent application. Considering Indian population is such huge, I think for your own area, I think India should be a big market to file as compared to Australia. So, but I leave it to your discretion because you are the expert here. You should do that market analysis and then take a call in which are the countries you would like to file.
Right, sir.
I think, Mr. Surya, there was another question on can software code be patentable, is patentable in India? That is a question which comes pertinently to us every time. So if you can throw some light on this.
Sure, sir. I just answered that. Please note that softwares are patentable in India. Only thing is that if your software is able to resolve a technical problem and is able to give some technical advantages, so please talk to the expert and get a patenting done. As you know that softwares are not patentable, so please don't take your programs or codes and then file a patent. Those you will not get a patent for that. If if you are trying to patent a software, then please consult an expert in that area so that the patent application could be well drafted in such a way that it would convince the patent office that it is not pure program or code, it is much beyond that, and your patent application sails through smoothly. Please note softwares are patentable, not the program and code per se, but what they're trying to do and what problem they're trying to resolve is what we need to think of.
Right, sir. So the next would be from Lakshmi Panath. Please allow me to pose the question. Yeah. Can you give sample patent application for software technology advancement for study purpose, and any link would do?
Madam, if they can write to me, I can Google, I mean, I can find those links and send it to them. So if they can write to me on that, so I can do that for them. Because I need to find such patents and then send it to them. Yeah, I can't do it now here.
Right, sir. So I think we.
Sir, another pertinent question is like it came initially. The gentleman was saying the patent grant takes something around 10 years in India. Is it true? And by the time the patent is granted, the technology becomes obsolete. So can you throw some light on this misconception that patent in India takes 10 years?
Sir, I just answered. I think that was the first question I believe I started to answer. So as I told, patents can be granted as just an expedite process if you go in 6 to 9, I mean, in 6 months to 1 year, you can get a patent. On an average, in my experience, I've seen in 9 months time, you should be able to get a patent if you're going through an expedite route. For startups, I think those things are available. If it's not a startup and you're trying to file an application as it is, currently what we're seeing is that patents get granted in 3 years' time. Patents filed in 2019 are getting examined and are getting patents now. And by end of the year, we'll have that patent. This was long back. I mean, if you had asked me 3 to 4 years back, I would say yes, it will take about 8 to 10 years to get a patent granted in India. Because now 3 years back, 3 to 4 years back, I think a lot of examiners were hired at the IPO, and they have cleared lots and lots and lots of backlogs, and they've done a very good job in that. And the idea is that I believe in next 2 years time, actually we should be able to get a patent in India in 1.5 years time. So that's the thing.
Yes, sir.
There is one question from Miss Yash here. Can you show us the search strategy for existing patent? I don't think right now is the platform or the time I have so that I can actually show that to you. Maybe some other time, if you can just drop in a mail, I can do that. Any more questions you would like to take up, Tina, from the chat box?
Kindly put some light questions. Anup Kumar Prasad here.
Yes,
For the
sir.
research paper one. Like, can I have, I had research paper on one of the device model. Okay. And can I go for a patent right now? I already published research paper and it's available under Springer paper. So can I go for a patent?
No, Anup, I'm so sorry to say that now that is in public domain, you may not be able to get a patent for that idea.
Okay.
However,
Is there any time period like within which I could do, or can I build a version 2 like with a slight modification and then go for the?
yeah. So if you're able to do some improvements towards that and make
Okay.
it a little more efficient, maybe you're able to get some advantage because of the improvement what you've done, then you can actually get a patent for it.
Okay,
And there
thank
are
you.
certain timelines for 6 months or so. I don't think the publication what you just mentioned that will qualify. Only if you had published under the guidance from the government or under exhibition which is sponsored by government, or in those conditions you had provision of 1 year to file a patent application. But considering what you said, at least for your case, that provisions I believe may not exist.
I'm getting recent mails from Australian patent. So should I go for it? Like they were charging some dollars and they would say that within 2 to 3 you would get the patent done. So should I go for it?
Within 2 to 3, what is it?
Months.
Yeah, look, I think they are talking about innovation patent there. Innovation patent are a little
True.
different than the other patent. So innovation patents, I think they will not even examine, they'll just grant a patent. And in Australia, I think this innovation patent, what they're talking about, will be closed by August. That's the information I saw on their website. I think after August, you'll not even be able to file that. So innovation patent as such, I mean, anyone can actually, you can just pick a publication, any publication and file it. Without examination, they'll just grant it. So for the sake of having it, you can have it. But later on, I think examination has to be done if you have to sue someone or if you have to monetize it. I think that's the time where
Okay.
the cost of patent will actually be known. So please be aware of that fact that there is no examination and the grant will happen just like that. And it's not a patent, it's the innovation patent whose patenting criteria is much lower than a patent.
Okay. And as you said that I can have a, I can also like look into the market area and then for the patent, like for Indian patent or the Australian patent. Can I have multiple patents on any device or on any model?
Yes, I mean,
Okay.
once you file an application for your device, the same application can be filed in other countries where you see the market. Second, you can actually improvise on that particular device or product and try to file more application for in and around that particular product.
Okay. As I'm in my early 20s, so should I go for that innovation patent with the Australian company, or should I just drop the idea and try to build a incremental model of it?
I mean, as I said, I think you need to take a call here because I'm not very sure about your market size and others. So once you file innovation patent, I'm told it is just a novelty checking one. You just check the novelty. If it is different, it is just granted. And I don't think it is available for methodologies. It will be available only for product. You need to check that too. And it's going to be absolute in August. And I don't know how the laws will be after that. So
Okay.
things is very specific here. I would recommend you to discuss this with experts.
Okay.
That discussing it here in the
Does
open.
India grant this innovation patent kind of things?
And no, they don't have the provision. They call it as utility patent. No, the bar set for to get a patent in India is much higher. That is, it's not that it has to be novel; it has to be inventive as well, which is a difficult thing to achieve. So now it itself may not help you to get a patent in India.
Thank you, sir, for your beautiful advice. Thank you.
Yeah. Thank you, Anu.
Yes, thank you, Naveen sir. I request you to share your email ID and LinkedIn ID, if possible, in the chat box for the benefit of our participants.
Okay, just a second. Okay, check. Let me do that. Just give me a second.
No problem, sir. Please take your time. Parimal sir, would you like to say something, please, before we close?
Yeah, thank you, Mr. Naveen. It was definitely very helpful information. And as you know that the CoE-IP is also providing the prior art search reports and all for mostly in the area of IT and electronics. And most of these services provided to the innovators for the free of cost. And I guess the CoE-IP is there at the ground level to help the innovators even from the filing it to the international level. In fact, there was a scheme we are trying to review lately, to which also gives a financial support up to 15 lakhs for filing up into the patents into the other countries. So we're looking forward to initiate such kind of initiative once again, and I guess it will be definitely helpful for all the innovators and startup. Apart from that, we are also looking forward to initiate the listing of various patent onto our portal and help them to commercialize, or for the licensing purpose, we would like to host it, the patents and the innovation, and we hope that will be definitely helpful for the whole fraternity from the startup and the innovation side. So thank you once again, Mr. Naveen from CoE-IP. And we look forward for such kind of a collaboration with you, and we look forward to guide our startups and innovators in future also. Thank you once again.
Thanks a lot for sharing this information, sir. I mean, this is information from me too in terms of what and all your organization is doing. I think I will definitely take this input and spread this word, and I'm sure not many people are aware of it. Thanks for letting me know this, and I'll do my duty of spreading this with others. Thank you.
Thank you.
So, Parimal sir, thank you for your valuable closing remarks. And this brings us to the end of today's session.